Morgan Lyndall, and I'm an attorney at the Butler Law Firm. Today, I'm here to talk to you about the anatomy of a lawsuit. A lot of people know if you've been in a car wreck or injured by someone else, you have the ability to file a lawsuit. But what exactly does that mean, and what are the steps that you go through after you file that lawsuit? So I'd like to start with the pre-suit period. This period begins once you sign up with our firm. We start pre-suit investigation. And during our pre-suit investigation, we do a lot. We will talk to witnesses, we will go and inspect the scene, we will look for cameras, video evidence from the scene, we will inspect vehicles, and sometimes, if necessary, we will consult with experts. For example, when you have a products liability case, oftentimes you need to speak with an expert to determine whether or not the case is viable, and that's important. So, once we've completed that pre-suit investigation, sometimes we will send a pre-suit demand. And the reason that sometimes is there is because the decision on whether or not to send a pre-suit demand is very case specific. There are a lot of variables that go into it, including your amount of damages, the amount of available insurance, as well as the type of case. Some cases have specific statutes that govern pre-suit demands. For example, a car accident has what's called the OCGA 911-67.1 statute, which governs a pre-suit demand in a car accident case. So it's important to consult with an attorney before you even file a suit or decide to send a pre-suit demand, because sometimes there are some requirements with pre-suit demands. So after you either send a pre-suit demand and it's declined, or you decide not to send a pre-suit demand, we will then file a lawsuit. And so the way you start that lawsuit, the case initiation, is what's called a complaint. The plaintiff or the person that was injured will file a complaint, and that complaint basically lays out the legal case against the defendant or defendants. That defendant will then have to file an answer to the complaint, which is essentially a response to what you said within the complaint. In that answer, they'll lay out their defenses, and they'll basically affirm or deny the allegations you've put in the complaint. After those documents are filed, or sometimes before, the discovery period starts. In the discovery period, we basically do a formal investigation of the case. Even though we've already investigated the case pre-suit, the discovery period gives us some more tools to use. During discovery, you can send written questions to the defendant, ask for the defendant to produce documents, and ask for the defendant to admit certain things. You can also ask the defendant to make certain things available for inspection, like a premises or a car if necessary. Additionally, you can do discovery towards third parties. So you can send written requests for documents to a third party. You can subpoena a third party for those documents. And if necessary, you can subpoena a witness for a deposition. You can also take depositions of parties. So there are a lot of tools within discovery to help further investigate the case. And I mentioned that sometimes discovery will start as soon as you file the complaint. That's in state court. In state court, as soon as you file a complaint, you can send discovery to the defendant. And we often do that. In federal court, you do have to wait 30 days after the defendant files an answer to be able to send discovery. So there are some differences, which again is why it is necessary to consult with an attorney if you're thinking about filing a lawsuit. After the discovery period is over, we enter what's called the motion practice stage. The motion practice stage is essentially the part where the parties can argue their case on paper. And essentially either the plaintiff or the defendant will say, we believe this case does not need to go to a jury, and here are reasons why. And the court will look at that and either grant or deny summary judgment, as well as other motions that can be filed, including a Daubert motion to get rid of an expert, or motions in limine to limit certain testimony or evidence from coming in at trial. So after the motion practice stage, assuming that the court has not granted summary judgment, you'll move on to the trial phase. And there's a lot that goes on with trial. There's all your pretrial stuff, the motions in limine I just mentioned. So trial is a beast in and of itself. And it takes a long time to get to trial, but when you get there, it's worthwhile. So once you march through trial, sometimes you have to go through an appeal. It's not an often thing, but sometimes there is an appeal stage, and it's necessary to fight that. Luckily, I have never been on the receiving end of one of those, but it is something that a client needs to be aware of. So that's basically the anatomy of a lawsuit. It's a long process. I know I've only spent about 5.5 minutes with you guys, but this process oftentimes can take years. And unfortunately, that's something that a client needs to be cognizant of, and sometimes the law moves like sap. I appreciate your time, and if you have any questions or concerns, please feel free to call the Butler Law Firm. We're happy to talk to you about your case. Thank you.